So one of the common challenges that people face when probating someone's estate is, first of all, finding the will. They may not know where the will is. They may not even know if a will was actually prepared. A lot of times people have an idea that a will was done, but they have no idea where it is, can't find it. If you can't find a will, it's as if it didn't exist. So if you have created a will and want to make sure that your family honors your wishes in that will, please make sure that someone knows how to find it. Make sure they know who the lawyer was that helped you with that will so that they can get, if not the original will, at least a copy of the will. If the original will can't be found, a copy of the will can be probated. There's a few extra steps that the probate process requires if it's a copy, but your wishes will still be honored if at least a copy of the will can be found. If there's no will, or if the will is missing and can't be found, it will be considered that you just didn't have a will, and your estate will pass according to the intestacy laws of Texas, which is an estate plan that the state of Texas has for you. It just may not be the way you wanted to handle things. If you don't have a will, or if your will can't be found and you have to go through the probate process as if there was no will, it's a much longer and much more expensive process to go through than if you just had a will that could be found. If you've executed more than one will in your lifetime and the most recent will can't be found, someone in your family may try to probate an older will. It's really important, if you have a will and you execute a new one, that you destroy the original will and try to destroy all copies of that will. So that way, if the more recent will can't be found, they don't try to probate an older will, which may contain wishes that you no longer want anymore. To make sure that your most current wishes are followed, destroy all old versions of the will and all copies of those wills. One of the best reasons for creating a will and doing your estate plan is to avoid family disputes down the road. The more clear you can make your wishes about how things should be handled, and if you appoint a responsible executor who will manage the process respectfully and in the way that you wanted it to be managed, that will go a long way towards avoiding disputes down the road. As a family law attorney who deals a lot with divorce, I have seen so many probate situations where there was no will or things weren't clear in the will. And when you've had those situations and the family is disputing the will or the lack of a will and how things should be handled, those fights are far worse and far mean and nastier than any divorce I've ever seen. If you have complex assets that will be passed to your family and loved ones upon your death, it's important to have appointed an executor who is capable of managing those assets, pulling them all together, and making sure they get distributed in the way that you want to. So if you have complex assets, you may want to have an executor who has financial experience, legal experience, or certainly knows how to get in touch with the right people that can assist them in managing those assets and transferring them in the way that they should be transferred, and also avoiding taxes on those assets. To make sure that you have a valid will that can be probated and your wishes honored, you want to make sure that you have worked with a lawyer that handles estate planning. Even better if that lawyer also understands probate, because they know the risks, the loopholes, the problems that can arise if you haven't executed your will properly. Many people think that they can go to LegalZoom or they can buy a document online and they'll just fill in the blanks and that will be a good will. It will be good powers of attorney and it will do what they want. The problem with that is you don't know what you don't know. You're not a lawyer. You haven't studied the estate code. You don't know what's going to happen with that. And these forms can be prepared from anywhere in the world. They may not be valid in Texas. They also may not be valid if you don't execute them correctly. You may get a document that says, do it this way, but they may not tell you that you need a notary and you need witnesses and you need to do it in a certain way. And if that will is not valid, it's almost as if you didn't have a will. So make sure, if you're going to go through the trouble of putting together a will, if you understand the importance of good estate planning, use a lawyer that knows what they're doing. If you have any questions about how probate works in Texas, please give us a call at DeFord Law Firm.